Greetings all. Welcome to webinar time. I am Chris Irons, Director of independent Strata, the consultancy firm Strata Solve. Alongside me, not literally, but alongside me nonetheless, Frank Higginson, Partner, Hines Legal and Industry Expert. Frank, welcome from sunny North Queensland.
Sunny, well, rainy North Queensland, but definitely North Queensland, yes.
Humid North Queensland.
Yes, always.
Humid North Queensland. I am in my usual spot. Just for anyone who's new to our show, we live stream to YouTube and Facebook every Thursday at 2 o'clock Brisbane time. So to follow on Facebook, go to the Hines Legal page, hit the like button and icon, and for YouTube, hit the subscribe button and the notification bell. Today, we're looking at a subject that comes up quite a bit, and I think it's a slightly misunderstood topic as well. We're talking about management rights, but specifically, we're talking about the assignment of management rights. In a nutshell, Frank, that means one management rights holder is moving on and is handing over the baton to the next. That's pretty much it, isn't it?
Yes, well, that's the essence of the transaction between the two management rights, well, I suppose the management rights owner and the management rights owner to be. And today we're going to sort of talk about how the body corporate gets involved in that and why they get involved in that and how the process works. And I think, mate, when you say it's sort of a largely misunderstood thing, there is a lot of these things go on in Strata, and this is a sort of fairly familiar dance routine to people that are in the Strata industry a lot.
Yeah.
But like everything we talk about, there's an enormous amount of misconceptions and confusion out there, which we'll try to clear up a little bit today.
We will. And on that topic, I know that Hines have got a pretty comprehensive guide to the assignment of management rights. The link for that, you will be able to click on that during and after presentation. Yep. So take a look at that. We're going to cover off the main points today, and there are a few of them, so hang on to your hats because we're going to do it fairly quickly. All right, let's start off with Frank. God, this sounds like a really obvious question. What are management rights?
Contracts. So they're not employment agreements, they're contracts. So it's like the best analogy, as I suppose, the same thing. It's the contract when you buy or sell a house. You know, that's one where I agree to pay you X dollars in exchange for you giving me title to your property. Management rights agreements are contracts as well, but they're not for the purchase of a house. They're for the purchase of services, in effect. Body corporate pays the management rights owner a remuneration of X in exchange for delivery of services described as Y. You know, Y is lawns, gardens, grounds, facility management, whatever it might be. And there's usually a parallel letting agreement with that where the body corporate authorises the manager to act as a letting agent for owners. And collectively, those agreements, in whatever form they might look like, they might be one document, they might be 3 documents, there might be a whole bunch of variations and the like throughout it. That is the management rights agreements that the body corporate is a party to.
Yeah. I think that contract part of it, Frank, is the really significant part here. It's not a case of just being able to unilaterally change things whenever you feel like it. It's a contract. Both parties have a role to play in the contract. We've covered that kind of thing in previous webinars, so we won't go over that too much today. Probably just a note to say that we're talking specifically about assignment of management rights today. But don't forget that management rights play a significant part in the operation of many schemes in Queensland, both big and small, and can really contribute to the value of both your lot and then the scheme overall, can also detract from it too if things don't go right.
So it's a business relationship that needs to be managed by everyone all the time. You know, and the other analogy I use for these in terms of why a body corporate gets involved at assignments is it's back to sort of simple property terms. It's like a, so if you have if you're leasing a news agency in a shopping centre, and you want to sell that news agency, you've got to go to the landlord and say, hey, I've sold the business, I've got a new tenant to take over. Yep. And in effect, that's what an assignment of management rights is. The body corporate would take on the role of the landlord, where the seller of the management rights goes to the body corporate and says, hey, I've sold, I've got this new great manager, Chris Irons, here's his experience, here's his qualifications. Is that okay by you, in effect?
Yeah.
And that's the assignment.
And that's why the body corporate gets involved, because again, management rights are so integral to the operation of the scheme that it would be stupid if the body corporate was not involved in that process somewhere. It wouldn't make any sense whatsoever. And remembering also that In a body corporate, it's all about making decisions. So you've got the committee as the day-to-day decision-making body within a body corporate, and that means generally they're the ones who are involved in the process on behalf of the body corporate. And in most cases, the committee is authorised to make that decision. Not all, but in most. I think that's fair to say, Frank.
It is. It's a safe assumption to say, unless it's been made a restricted issue, the committee can absolutely make that decision. That's very clear in the modules. Although sometimes, occasionally, committees might want to throw the decision up to general meeting if they're feeling particularly nervous about it, but that's a pretty rare occasion.
Yep. Okay. So, look, naturally enough, the legislation talks a little bit about this. You can't do anything in Strata without legislation talking about it one way or another. And in this case, when we talk about assignment, we have this thing, Frank, where a body corporate cannot unreasonably withhold consent. What does that mean?
Yes. So it's a little bit of, I suppose, an extension of what we talk about as being the normal duties. Bodies corporates can't act unreasonably. This one is, again, akin to leasing. So really what unreasonably withholding consent to me means is that the body corporate can't say no to the buyer unless there's really good reasons to say no. So there's a process to follow through there. So, for example, if a seller of a management right served up a buyer who had a criminal conviction for trust account fraud, that's probably a good grounds to say no. Probably the ones we do see which are difficult is where buyers have previously owned management rights and had very, very difficult relationships or issues with previous body corporates, where experience dictates that they might not be the best person for the role. But it's not like an assignment request to a committee. It's not like a job interview where you put an ad on Seek and you get 15 applicants and you interview the best 5 and you pick one. This is one where a buyer will be served up to a body corporate committee, and unless there's good reasons to say no, the committee effectively has to say yes. So it's not quite, it's almost a reverse onus of proof, would be one way to put it, where the committee, if it wants to refuse consent, is going to need to say why it's refusing consent, and that needs to be on reasonable grounds. And that's not, we don't like the way they look, we don't like the way they talk. They have more substantial to that. And obviously that's about probably a week's worth of webinars. So that's not the issue today, but that overriding thing is unreasonably withholding consent. So it needs to be, it's a yes unless there's good reasons to say no.
I think that's a really good way of putting it, Frank, and you're quite right. That's its own webinar series, that one. Let's talk a little bit about the legals. Gosh, I hope we have a lawyer here. We do. Frank, what are some of the legal bits and pieces?
Well, like anything, I suppose, that is a legal transaction, there's documentation to go with it. So the starting point is to make sure that whatever the body corporate's been asked to sign accurately reflects what the position is from the body corporate's perspective. So normally the way these things are documented is that all 3 parties, body corporate, seller and buyer, sign on to the one document that records what's happening. So that document will say between seller and buyer that the seller sells the management rights to the buyer accepts the assignment from the seller, and the body corporate consents. So they're the 3 core elements of any deed of assignment. And then it's not uncommon, well, it's common practice for there to be a bunch of additional provisions that relate to any number of other things. So from a seller's and buyer's perspective, and particularly from a buyer's perspective, what the buyer is looking for from the body corporate is usually confirmation around some things, like, for example, that the seller's not in breach of the agreements. Because if the seller is in breach, the buyer might be inheriting those problems. And from a body corporate perspective, if the buyer is a company, it's very common to ask for personal guarantees from the directors of the company and some other assurances that if the company doesn't perform, that the body corporate's going to be covered. So there's a range of issues that usually a document will be served up by the seller to the body corporate to say, here's what we'd like you to sign. And it's not sort of people trying things on, but it's common for bodies corporates to be asked to sign things that might not necessarily be consistent with what the agreements might say or what the body corporate's obligations certainly are. What common practice might be or what the body corporate wants to give. So at that stage, it is important for a body corporate to get legal advice so it knows what it is that it's signing, and if it is giving away rights, that the committee is doing it knowingly.
That contract issue again, that's what we're talking about at the end of the day. Let's talk about money, for a moment, Frank, because that's always a big issue. It's a big issue here as well. There's this mysterious thing called a transfer fee, Frank. What is that?
There is. So we're back to the genesis for this is a really interesting story, but we'll leave that aside for today. We're back to when the legislation commenced in 1997 that this appeared. So I wrote a newsletter on that years ago, which we'll put up, and that position hasn't actually changed from what's in that newsletter. So it's a very uncommon thing in commercial practice, but it's in strata legislation. And in effect, the rationale behind this was that bodies corporates get disturbed, in effect, by transfers of management rights. It means that people are going to need to reinvent relationships, go through education, get to an understanding that existing relationships have again. And this transfer fee is effectively, I think, a form of compensation for the body corporate with respect to that. So what happens is if a resident manager sells their management rights agreements within the first 2 years of them owning it, they've got to pay a fee to the body corporate, which is this transfer fee, that is a proportion of the sale price of the business. So if they sell within 12 months from the date they settle to the day the body corporate committee consents to the next assignment, it's 3% of the value of the management rights business. So not the real estate or any real estate associated with. And if they sell in the second year, it's 2%. And after that, there's no transfer fee payable forevermore, provided the agreement continues. The other thing that's a little bit different that used to be the case but changed in 2008 with the legislation is that the imposition of a transfer fee by a body corporate is compulsory. It's not something the committee can elect to waive. There used to be that right, but that's not there anymore. So it's really now, again, this is one of those legal advice things. A transfer fee, if an agreement is assigned within that statutory period, must be imposed unless the management rights seller is selling the business because of genuine hardship that wasn't reasonably foreseeable by them at the time they bought the business. So, so I suppose, what are the golden rules here? If you're outside 2 years of ownership, then, well, if the manager's outside 2 years of ownership, it's not going to be applicable. If they're inside 2 years of ownership, it's got to be applied unless there's genuine hardship. So we haven't really litigated one of those for many years. Before 2008, there was quite a bit of litigation around what was genuine hardship, and that really, like all good legal issues, depends on the facts and circumstances.
Absolutely. Well said, Frank. We're really ripping through these today. Let's keep going then while we're on a roll. We've heard sort of a bit of discussion about the commerciality of things from the purchaser, I guess, perspective, or the management rights holders perspective, but sort of flipping that around a little bit. From the point of view of the body corporate then, Frank, what things do they need to be aware of that protect their, and bearing in mind that the body corporate can't conduct a business, but putting that to one side, what things do they need to be aware of to protect their commercial interests?
So, I mean, the legal bits are the legal documentation. That's well and truly a lawyer's domain. The other part, though, is as much as we're talking before about bodies corporates not unreasonably withholding consent, the body corporate's absolutely entitled to know that the buyer's capable of doing the job. So the way it works is that the modules set out a number of things that the body corporate can have regard to: competence, qualifications, experience, training, the terms of the transfer, the buyer's financial soundness, then the agreements can add other things to that. Might specifically deal with references, resumes, certifications, bank opinions, and so on.
Just here's a random question for you, Frank. Is a police check or a blue card check ever included?
I think a blue card, no. Police check, I think, is a reasonable request. And interestingly, we're now starting to see committees ask whether buyers are vaccinated.
Is that right?
That is right. So I haven't seen any fights about whether a refusal because someone hasn't been vaccinated. I think it's quite possibly unreasonable. But in terms of asking the question, it's happening.
Okay. Interesting.
So, and I suppose this is one of the issues that comes up always with Strata is committee members are volunteers. Usually they're not trained in assessing the bona fides of a buyer or a buyer's competence, qualifications or experience and their ability to do the job. So you can certainly get advice on that from us or from other people or from other assessors, Chris, that might understand what goes into a management rights business and whether the buyer's got the ability to do the job. And it's certainly, the way it works, it's not necessarily the committee's job to go digging. It's for the seller to prove to the committee is, I've got this buyer, here's all of their material, they're well and truly capable of doing the gig.
And so that, yeah, just to pick up on that point, like I've certainly in my business been approached by people wanting to know if I can offer some kind of basic training for an incoming management rights holder, and yes is the answer. And I think, Frank, where we're getting to there is that's a reasonable condition, a relatively common one too.
It is absolutely becoming more common. So I think, and it's really about raising the bar, like from an industry perspective, and this is across the board. The higher the bar is raised, the better the caliber of the person coming into it, the less need there is for us to be doing things like this. You know, even understand the way the process should work and how, you know, that triangle of management in a strata sense works, and who does what and how it gets done and what the roles actually do and don't include. Like, the more training that goes into a buyer before they arrive into a management rights business, the better it is going to be for everyone, because it's going to take away some of those immediate misconceptions that new people don't understand.
Absolutely, yeah.
So committees are entitled to understand those things, and so the training's not necessarily just from the seller. It's what external training have you done.
It's also fairly common practice, Frank, isn't it, for an interview to happen with the incoming?
And interestingly enough, there's nothing in the legislation about that, and it is relatively uncommon for an agreement to refer to an interview, but it is well and truly common practice. And what we say to everyone acting for buyers or acting for committees, you only get one chance to make a good first impression. So as much as, you know, I'm talking before about not unreasonably withholding consent, only saying no unless you've got really good grounds to say no, you only get one chance to make a good first impression.
Yep.
And that applies both ways. From a committee perspective, you don't want to go in, from my point of view anyway, you don't want to go into a committee interview with a buyer and basically go into a triple C star chamber and put a spotlight on them and hammer the daylights out of them and all that sort of stuff. And from a buyer's perspective, you don't want to go in and do the thing half-assed, for a better phrase. Be professional, present professionally. It's a great way to start a professional business relationship.
Absolutely. Interviews are common practice in life, in pretty much every walk of life and every kind of work. So I reckon it's probably not a bad idea to apply some of the principles that you see elsewhere in interviews to this kind of thing as well. So make it accessible, you know, make it reasonable conditions, try and make it as open as possible, try and dial back the hostility, declare conflicts. That's another good one.
And deal with expectations.
Yeah,
this is what our expectations are on both sides, you know, without being dictatorial about it.
Ask reasonable questions and be prepared to engage. I think that's all makes sense to me. Let's talk a little bit about timing, Frank. What are some of the timing issues at play here?
Well, the wonderful the legislation says that, and it's important to point out that no matter what's in the agreement, the legislation overrides it. So, for example, a management rights agreement might say a committee's got 60 days to consent to an assignment. The Act says 30, or the module says 30. It is 30. So the legislation says that a committee's got 30 days from the day it receives all information reasonably necessary to consider an assignment to make a decision. So, so that 30-day clock doesn't start ticking the day the seller says to the committee, hey, I've sold. It starts ticking the day that the seller gives the committee everything necessary to consider the assignment, and then that means they've got material that addresses all of the criteria in the legislation and the modules. So it deals with financial standing, it deals with competence, qualifications, experience, it addresses training, it deals with the terms of the transfer. And if you haven't provided that, or the committee hasn't been provided that, that clock does not start ticking. So it's a really important thing. And I suppose, Chris, this is the relationship element of this, because as much as we're sitting here talking about what the legislation says, the reality is relationships drive a lot of the behaviour in Strata. You can almost rest assured from a management rights perspective and a committee perspective is if the committee and the current manager aren't really getting along famously, that you can expect the assignment process for a new buyer potentially to be a little bit more rocky than if they were getting on famously, because the committee is usually going to look at a buyer and say, we don't want to be in the same boat we are with you, mate, to the seller, and we want to make sure that these guys have all of the material that potentially we think you haven't got.
It's just another factor to throw into the mix, isn't it? And what's that old saying? The best guarantee of future performance is past performance. It's a bit similar here, isn't it? Just as you said, Frank, if things have gone poorly between current management rights holder and committee, it's only natural that some of those unfortunate incidents will be brought to bear.
And it's hard to blame for committees when that happens. You know
Yep.
what I mean? So I'm not going to go from the frying pan into the fire. I want to make sure that this is right. So, and that's an issue for management rights sellers to make sure they're around that if they're going to do it. And from a committee perspective, it doesn't take away the need to assess the buyer properly and ideally dispassionately, not unreasonably withhold consent. But you can just absolutely expect for the committee to want all the I's to be dotted and the T's to be crossed.
Which leads us very nicely into one of our final points for today. Where does it all go wrong? And I think we've just highlighted the big one there, where there's too much emotion involved and it's not being treated in a business-like fashion.
Yeah, and it is a business transaction. That's the reality of it. I know it relates to people's homes and there's always an overlap with that, but it is a business transaction. And really importantly, from a committee perspective, there's statutory obligations to do certain things. You know, from a manager's perspective, there's contractual obligations to present material. And where, to me, the issues really come up is, that relationship might have some issues that cause division. But then when communication breaks down about what concerns might be, or people decide to be deliberately difficult for a reason, that gets really twisty really quickly. Because what usually, in a management rights owner's sense, you've got someone trying to sell a business and someone trying to buy a business. And what I see occasionally, acting more so than anything else for sellers of management rights who are in difficult relationships, because we'll play both sides of the coin, the mercenaries that we are. Quite often, the buyer can be the meat in the sandwich that is the consequence of issues between the seller and the body corporate. And so the buyer's coming into this innocently and happily and willingly, it can really poison the well early in terms of that relationship if the committee takes out the issues they've got on the seller effectively against the seller, but the buyer gets caught in the crossfire. Yeah. So from a body corporate perspective, you've got to be real careful with that, because it's the reality is these management rights agreements are long-term relationships, and you need to have a working relationship, and it's not, they don't go away, they're there. So from a committee side of things, you want to make a real conscious decision before you load up effectively and make a difficult transaction for a buyer, unless, there might be genuine grounds to do it. And if that's the case, then you've got to do what you've got to do. But recognising that most assignments usually happen, starting a relationship on the wrong foot with someone that you're going to have a long-term one with is not necessarily the best place to be either.
No, it's not. It's not. You've got to, again, try and be business-like about it. A few other things here to go through, and we've kind of touched upon a number of these already. Treating that interview as an interrogation, that's a big kind of no, big red flag. And from the flip side of that, not being prepared for the interview, it's your big opportunity to sort of put the best front upon everything, and both parties should be taking that opportunity.
Yeah, what I'd say, our process when we're acting for committees in relation to it is we'd like to get a bunch of questions out to a buyer with answers back, so that it's not a sit there and, have you ever been convicted of a criminal offence? No, and the committee ticks the box.
Well, that's a waste of time, isn't it?
It is, yeah. It's all this stuff is, you almost deal with it by exception then. So you ask all the answers are all appropriate, then you drill down onto the things that actually matter. And that might be expectations, and it might be, well, what happened here? Or it might be your previous experience with this particular occasion. So you can spend your time on the things that matter, not the stuff that is effectively just done. Tick, 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 tick.
Yep. As before, unreasonably withholding consent. So withholding consent just for the hell of it. Those sorts of things, that's obviously where this sort of thing goes a lot wrong. Not factoring in enough time in the process. That's a fairly common one in Strata generally. Everything that happens in Strata usually has a defined time frame, which goes with it. And as much as we might want to hurry things up or extend things in some cases, there's no option to do it if the legislation says it occurs in this time frame.
And there's a process that you should follow from a committee side of things to do a due diligence. Like, it's,
Absolutely.
hey, I've sold the business. Here's the consent. I'm trying to settle tomorrow. It's like, well, from a seller's perspective, that's a bit unrealistic and unreasonable to say to a committee, turn it around that quickly.
Yep, exactly. Exactly. We talked before about antagonism that already exists for other reasons, flowing through to the transaction for somebody who has nothing to do with the antagonism. And that's about the ability to try and draw a line and treat this as a kind of a new dawn, if you like. One of the things that we might just quickly touch upon, don't need to labour this point too much, is that there are ways to actually do that. So from my experience, I've actually been in a situation where I've conducted a mediation between caretaker and contractor, caretaker and committee. They already had the lawyers appointed to do some work around the contract. Point of me doing the mediation was to actually try and resolve a couple of points of antagonism. So a set of 10 issues narrowed down to 5, for example, is far easier to deal with at the sort of the pointy end than if it was still 10. And it also helps pave the way for things to be a bit more open into the future.
And the moment people start collaborating, it's not hammer and tongs on every single issue. Like, oh, we can reach agreement on this. We can reach agreement on that. And that paves the way to sorting things out. So, mate, absolutely. And I think if I look back at some of the difficult transactions that we've had over the years, wheeling in someone like you to say, righto, let's have a conversation and figure out what this is really all about, would have sorted it out. Because again, from a seller's perspective, they want to get the deal done. And from a committee perspective, you're a volunteer doing this to try to make sure the building gets looked after. But sometimes people lose sight of the forest for the trees when the relationship breaks down.
Absolutely, Frank. One final thing, Frank, and the big question I'm sure a lot of people will be asking, who pays?
The seller pays the body corporate lawyer's costs, because the only reason that the body corporate's being put to the expense of getting legal advice on assignment is because of the seller's request. So that's the reasonable costs. Obviously, that's another one of those magic words. But by and large, it's a seller's problem to make sure that the costs get paid. And part of our role as body corporate lawyers is to lock that down when we're acting for a body corporate on assignment.
As you say, Frank, it makes sense because they're being put to the effort of doing so. I hope you've been able to catch up or keep up, everybody, with that. That was pretty rapid fire stuff, and it's very, very high level as well. But I hope that's given everybody a flavour for the whole assignment process. It's not simple. It's not simply a case of, here you go, here are the keys, see you later. No, it's a bit more involved than that. And both sides have got some responsibilities and obligations along the way. Now, don't forget, we publish some show notes post-webinar or post-podcast where we sort of expand upon a few points, provide a few links, and give you a few tips that go towards what we spoke about today, so you can grab those afterwards. And a quick reminder again that if you are new to the show, we live stream to YouTube and Facebook every Tuesday at 2 p.m. Brisbane time. So to follow us on Facebook, you go to the Hines Legal page and hit the like button and icon. For YouTube, you hit the subscribe button and the notification bell. If you want to get in touch with me, www.stratasolve.com.au. I think we've got there, Frank, to the end.
Right. That's sometimes people say to us, you spend too much time talking, and today we have rattled off everything, and there's still stuff. You want more detail, have a look at that guide, or absolutely reach out to either of us.
Yeah, absolutely. With that, though, we just want to say, as always, thank you for tuning in. Thank you for listening. There's a lot of stuff going on in the world and a lot of demands on your time when you're in Strata. So we appreciate you devoting some of yours to this. And Frank, thank you. Enjoy the trip back from rainy Cairns.
Well, I'm not in control of the plane, so hopefully I've got a competent pilot.
Fantastic. That's what we want to hear. But yeah, we will see everybody next time. Thanks all.
Bye, everyone.